Friends, come on in. Hello there, Instagram, McBean Immigration TV, welcome. Facebook, welcome. And TikTok, welcome again. I'm Latoya McBean Pompey, an immigration lawyer in New York, working with clients nationwide at McBean Law. It is Saturday afternoon and it is raining outside, which means I cannot do any gardening today. So I sat down and I started to brainstorm some strategies on how we could fight back on this USCIS memo that came out yesterday about adjustment of status. And I have some very practical tips and evidence, a list of evidence to share with you in this live session so that you will feel more empowered and not despair. Okay, this session is all about how to present the evidence to the government to allow to so that you could adjust your status in the United States the way that it was intended to be if you're eligible for it, of course. So if you'd like to be part of today's live session, come on in, bring your great vibes on this Saturday. Do not despair, do not panic, do not do not lose heart, guys. Let's strategize together. You could also grab your pen, your paper. Be sure to save this live session so that you could go back to it. You could even screenshot the information that I'm about to share with you. These are my thoughts, my original thoughts on how you could strategize and push back and succeed, really. I'm not guaranteeing any degree of success here, but what I do guarantee is some degree of confidence that you'll feel knowing that, oh, it might be possible for me to actually stay in the United States and get my green card despite the memo that USCIS shared with their officers yesterday, as well as the rest of the world. This is the biggest news right now in America. It is the top news on pretty much all news outlets. And so let's get into how you can push back. And if this is something that you're interested in, stick around, okay? If you'd like a consultation with us, we'll be back in the office on Tuesday. Monday is Memorial Day, so our office is closed on Monday. You could reach out to us. However, we're still on the phones. You know, us at McBean Law, we will be on that phone answering your calls 7 days a week. And so you can call us. Today, the office is now closed, actually, 6 o'clock, but between 9 and 6 Eastern time, 9 a.m. to 6 p.m. Eastern time on the weekends, you could reach us. And then certainly during regular business hours during the rest of the week. We could be reached at 914-898-9488, or you could simply send an email to McBean Law email account at info@mcbeanlaw.com. Now, USCIS friends yesterday blindsided very many of us by sending a memo to its officers and the world stating that um, they would prefer for you to not do adjustment of status, really. They would prefer that you would apply for a green card at a U.S. embassy or consulate in your home country, not here in the United States. If you've entered the United States with a temporary visa, with a non-immigrant visa, something like a student visa or a visitor visa, they are now saying that according to the laws, administrative grace should be granted to some people with respect to adjustment of status. It's an extraordinary relief. It is not something that is routine and ordinary and something that should be granted to anyone who applies for adjustment of status. So now that's the policy thinking. And the instructions to the officers yesterday is that you've got to look at this applicant very carefully and very closely and balance some factors about this individual. Look at the whole picture, the total picture of this applicant that is in front of you, and consider what is positive about this person and what is negative about this person. And there are some very important things that you really need to think about this applicant as you make the decision to grant adjustment of status or not. But again, our preference is that you do not grant adjustment of status. That is USCIS's position. Now, I will share with you in this live session also an update that the spokesperson for USCIS provided to the press yesterday. Let me do that part first. I'll do that first, and then I'm going to go into my notes. The Business Insider, okay, reported that the Trump administration says green card enforcement likely won't apply to those who provide an economic benefit. No surprise here, right? That the government is looking at maybe carving out something for individuals who could prove that they have the financial stand-in, so to speak, to adjust their status, and also people who this government, and I'll pull up the quote here, people who the government thinks should be granted a green card based on national interest. And this is the quote that the USCIS spokesperson Collar said to the media. While we work to operationalize this, people who present applications that provide an economic benefit or otherwise are in the national interest will likely be able to continue on their current path, while others may be asked to apply abroad, okay, dependent on individualized circumstances. This is the latest statement from USCIS. By the way, if the audio is good on your end, let me know that the audio is good. And is it good? Double tap and say it's good. I'd like to know if it's good on Instagram and McBean Immigration TV. If the audio is good, let me know. Okay, so the economic economic benefit is important to the government during this adjustment of status process going forward. And people who could show that granting the green card to them is in the national interest. I believe more is going to come from USCIS that further drills down and explains more about what their expectations are and what they're looking for, and which categories of green card applicants they are going to carve out and say, okay, you don't, we don't need to hold you to this new heightened extraordinary relief standard, okay? For now, we know it is people who can provide some sort of economic benefit to the government, maybe business owners, I don't know, and people who are in the national interest. Now, let's get into my notes about how they're going to balance these factors and really what they're looking for, okay? What they're looking for. And this applies to my knowledge, and based on the understanding of some immigration attorneys who I've seen comment on this new memo or talk about it behind the scenes, this does apply to cases that are currently in front of the government, pending cases, okay? Cases that are there right now, okay? Your case that you have already filed. So what are they looking for? The officers have been instructed to look at whether you have any violations on your record. Have you violated the immigration laws or any conditions of your immigration status? I'm going to break this down a little bit momentarily. So for instance, if you held a status like the F student visa status, did you violate those conditions by maybe working without authorization? I don't know. Or obviously you violated by overstaying your visa, and some other violations might very well be on your record. Now, the second area that they're looking for is if you had committed fraud on previous applications or provided false testimony. It says current or previous instances of fraud or false testimony when you were dealing with USCIS or any government agency. Okay, any government agency. And it doesn't have to be an immigration agency that you committed fraud against. It could be um, any state or federal agency that you've interacted with, and the USCIS found out about that fraud. Furthermore, they're going to be looking at whether your application for admission, I'm just reading this verbatim, but I'm going to break this down in layman's terms momentarily, whether any alien's application for admission or parole violated the laws, regulations, or any policies that are in place. And then number four, any conduct that the alien took, okay, any conduct of the alien after admission to the United States as a non-immigrant or a parolee that is inconsistent with the purpose of that non-immigrant visa status, or representations that were made to the consular or DHS officers when applying for a visa, admission, or parole. Now, here's the key takeaways. Key takeaways in natural language. Natural language. They're going to scrutinize your intent with respect to coming to the United States, scrutinizing your intent in coming here, and certainly your conduct after you came to the United States. Okay, after, let's see, hold on a second here. That's what the focus is now, scrutinizing the intent. What did you tell the embassy? What did you write on your visa applications as to the purpose of your trip? What did you do after coming to the United States? Did you immediately start working? Did you settle down? You got married? You dropped out of school, or you didn't enroll in classes? You got married to a US citizen and quickly applied for a green card? What is this conduct that happened right after you came to the United States? And is it inconsistent with what you originally told them the intent of your visa was at the time that you applied? Remember, the intent of these visa certainly is it's a temporary stay in the United States. In times past, you didn't have to be prepared to answer questions about your early conduct in the United States. Now, under this new policy, you might have to go back and think that through a little bit in the event this comes up during an adjustment of status interview, because they are still moving forward with the cases. They're not abandoning these cases that are pending before them right now. They have an obligation and a duty by Congress to do that work of adjudicating these applications, okay? And if you apply for adjustment of status on Tuesday, they will accept your filing fees, accept the application, and they will begin processing it. So what happened yesterday doesn't stop that process, and it doesn't stop individuals from seeking adjustment of status. It just makes it a lot harder to get it, and which is why this live session is so important to me, to communicate how you could actually win and overcome in this circumstance, in this environment. So be prepared, guys, to go back to that early conduct and look at what was going on with you during those early days so that you could prove that your intent wasn't even to stay here permanently and apply for adjustment of status. So what evidence do you actually have, right, for why you ended up staying? Was it a medical reason? Did you actually seek an extension of stay in good faith in those early days? Was it more dangerous for you to return home? Did you seek asylum in a timely manner? Did you have a baby, which made it more difficult for you to return home? You know, during consultations over the years with clients, somehow foreigners actually think about these things, these questions that I'm asking today. They think that, oh, I've got to explain all of this to USCIS as to why I overstayed, what was going on back then. And I would tell them that's not really relevant. Don't worry about that. You don't have to explain any of that. Now I think you kind of have to refresh your memory and think about it, because they're looking at conduct that happened after you entered the United States and what you told CBP Customs, or what you told the U.S. Embassy was the purpose of your green card, your visa application. Okay, so just refresh your memory. Now, what else do you need to really start thinking about? What did you say on earlier applications, guys? You've got to request those FOIA records, request those Freedom of Information Act records from the State Department, and request those visa applications. If you don't have a copy of that visa application, it's very easy to request the records, get those, get your records from USCIS if you've ever had a case that you filed to USCIS in times past. Some people will also need records from Customs, CBP, particularly if you were ever pulled into secondary questioning in years prior. You've got to know what you've said to the government in times past so that you're not blindsided at these interviews, okay? So be prepared to answer these questions about earlier statements that you've made on your applications. The next question to think about is, what other immigration laws have you violated? We know you've overstayed. They know you've overstayed. Okay. The law says, well, normally that's not even an issue. And now they're making it an issue. Okay. Aside from overstay, what else? What else happened with you? Did you violate the terms of your student F visa? Be prepared to file an I-601 waiver. Be prepared for that. Did you work without authorization? Now, if you did work without authorization, without a work permit over the years, your lawyer will, or whoever you decide to work with, if you decide to work with anyone, will really need to make it explicitly clear in your filing that the current laws do not penalize you if you're an immediate relative of a U.S. citizen and you've worked without authorization, okay? Or you're seeking adjustment of status through a humanitarian pathway. By the way, my early understanding, and I'm certainly not the expert on this memo yet, but is that refugees are exempt from this, okay? But spouses of U.S. citizens are not. Children of U.S. citizens are not. Parents of U.S. citizens are not, okay? Exempt from this quite yet, okay? We're still waiting for more information from USCIS, but now you've got to put on your war hat and you've got to strategize and start thinking about how to win your case in the event you get a request for evidence or you get a notice of intent to deny, or they just deny it based on negative factors that they see on your file. Be prepared to fight this. The next question is, did you commit any fraud or give any false testimony in the past? And if so, you've got to own up to that at this, in a strategic way and be prepared to file an I-601 waiver and prove hardship to the qualifying relatives, okay? One relative. If you filed a previous case that resulted in a denial, get your FOIA records to get clear on the problems that USCIS had with your case. It's very easy to do, again, to get those records and look to see any notations that an officer made over the years in your file. It is incredible. It is incredible to me the number of times I've met with someone in a consultation who say to me, oh yeah, I had a lawyer once who got my FOIA, or oh yeah, I did pull my records from immigration. And then I said, did you read it? No, no. Guys, you cannot be lazy now going forward. I should say going forward, you cannot be lazy. Like right now, I don't even feel like being here. I would love to be lazy in this moment, but I cannot. You've got to fight. You've got to read your file. You've got to go into those 400 pages, or for some of you, 1,000-page FOIA, and just, scroll through and see what you see and know what you'll know, so that you will be able to really be confident knowing, oh, okay, I did see this in my record. It looks like I might need a waiver. Let me, ensure that my attorney understands this as well. So get those FOIA records, guys, to become clear about what problems USCIS had with your old case. And any previous fraudulent filings, guys, will likely lead to a denial of your adjustment of status case. Like if you've had an old LULAC fraudulent application, or if you applied for TPS claiming that you're from Cameroon when in fact you're from Ghana or another country where TPS is not available, or you submitted a fraudulent DACA application alleging to be, a certain age, and you're not that age, or you were not in the United States on that date when you were supposed to be, for the cutoff of DACA, or if you've committed fraud with your visa application, the DS-160, or for some people, you know who you are, it's a DV lottery kind of fraud. If you have any previous fraudulent applications, just know that it is likely to lead to a denial of your adjustment of status case. But again, be prepared to file an I-601 waiver. Now, let's talk about the good stuff, the positive factors that you could show USCIS. This is where I think it's very important for you to maybe screenshot if you'd like. If you're watching this on YouTube or Facebook, screenshot this, okay? What positive factors can you show USCIS about yourself? Well, number one, your family ties. Do you have U.S. citizen parents, a spouse, children, or other relatives? Who do you have here in the United States who have status? Status. I would even throw in the green card holders into this too, by the way. Green card holders, I would even throw them in here. If you have green card holder parents or children, who do you have here who is in lawful status as a U.S. citizen or a green card holder? Consider those people. That's a positive factor for you because now you're tied here. Tied. Number two, do you otherwise have a clean immigration history? No fraud on your record, no bad filings? Well, that's something really important to point out in your case. Are you in current lawful immigration status? Do you have TPS, DACA? Maybe you're still here on an F visa or H-1B visa or some other non-immigrant visa, like maybe an L visa or something. Point that out. Moral character. This one is huge. This one, moral character is normally tied to naturalization. Yesterday in my video, I made a mistake and I said adjustment of status, but I was going too fast. I meant to say naturalization. Moral character is connected to naturalization. Now they're bringing it into the context of adjustment of status, but not to worry, this could be handled. Think about the fact that you want to show or explain any criminal record. Do you have a criminal record? You might have a minor one. It's minor. Well, make sure that they understand how minor it is. Or if you have no criminal record, excellent. No criminal record. Do you pay taxes? Have you paid taxes? Do you support yourself and your family? That's good. Do you pay your bills on time? Do you have a decent or good credit if you had a social security number, right? If you have a social security number. Do you volunteer? Or do you have any civic involvement? Gather all of this stuff. Now is not the time to be, shy about some things. You've got to really think about the fact that you're a pretty decent person and what do you have to show for it. That's going to be important now. Finances. Okay. Financial issues. Why did I throw this on my list? Throw this into this bucket here of ways of fighting back and things you need to begin working on. Well, because several weeks ago, USCIS Director Ed Lowe said, self-sufficiency. Folks will need to be able to prove that they are self-sufficient when they're going through a green card process, which led me to believe that they're going to have us place a stronger emphasis again on public charge and self-sufficiency. That's still to come, I believe. And so, in this context, friends, where USCIS, the spokesperson, told the media that they're looking for people who can provide an economic benefit to the US, or people who are, we find to be in the national interest. Well, I think obviously we know financial issues will be important to show. What is your income, or what is your employment history? Do you have an employment history? Have you been working here? Hard to prove if you came to the United States at the age of 65 and you're just the parent of someone here who wants you to now settle down here so that they could, take care of you as you grow older. And so you don't really have much of an employment history to show here. But maybe you have some assets or some savings. So savings and assets, like you could show those aspects of things through bank statements, tax returns, mortgage statements. On the income and employment history side, of course, W-2s or 1099s. And then education. Do you have any diplomas, degrees, certifications, licenses? Those are good to show. Okay. Then your length of time here in the United States is also important. You've set down roots in America. It's not very easy to uproot those roots if you've been here for 10 plus years. Um, and then if you have anything else that shows your accomplishments, like medals, recognitions, anything, like that you could accommodate. I didn't want to say the word because I knew it was gonna be a blunder, but it keeps coming in my mind. I'm not gonna say it. I'm not gonna say it. Today is not the day for that. You guys know what I'm referring to. Any achievements, any accomplishments, in your area, whatever it is, it doesn't matter how small it is. Bring that up, bring it into your case. And then certainly if there's any sympathetic factors that you have that you could show about a close US citizen relative. It could very well be something like a medical condition, or maybe their financial dependency on you, or something of that nature. You'll want to also include this. You might be saying, and this is, by the way, the end of my evidence list. You might be saying, my goodness, this is a lot. What is going on here? Is it even worth it? Why should I, why do I have to go through all of this just for a green card? That's your question to answer, right? That's your question to answer, because you know that there's quite a bit of value in getting that green card, that residency, and then later on US citizenship. It could be completely life-changing. It changed the entire trajectory of your life and your children's life. And it has a generational impact. Your income can go up. Things can change for you drastically. And I think many of you understand that, you get it, which is why you're watching me on a Saturday when you could be doing something fun, but you're not, you're here. You see that there's value in this. Please screenshot this. Now, these are just my thoughts on things that you'll need to begin pulling together. And I really suspect that USCIS is going to begin to send around to individuals requests for evidence, very similar to what I've discussed here today. Um, Take it very seriously, the request for evidence. Don't be caught off guard by it. Be prepared, because you remember that lady on that Saturday and Memorial Day weekend, when everyone should be resting. She came live on you. She went live. Okay, she went live. So friends, you could do this. We could do this. You could still overcome, and you could still get your green card through adjustment of status. You don't have to be fearful in this moment. You don't have to be. You could strategize and you can win this. I did see in two places, I saw, I cannot verify it, which is why I did not pull it up in front of you in my session, because I don't want anyone to say that McBean is sharing incorrect information about this. But I did see circulated, and I suspect some of you also might have seen it, a request for evidence that purportedly was issued yesterday at an interview for adjustment of status in a child parent case. And even an immigration attorney shared it in our listserv. I saw it this morning and I thought to myself, I'm not going to pull this up into my live session today because I don't even know where it came from. I don't know the credibility of it, but on that checklist, that request for evidence, it did mention quite a number of the documents that I have shared with you here. So we'll find out over the next week or two whether that request for evidence is genuine and true, as more immigration attorneys share their experiences with us. All right, now, um, was this good? Do you feel a little bit more like, oh, this is doable? I can prove that I can benefit from this administrative grace, this extraordinary relief that they're calling adjustment of status. Do you feel a little bit more confident? Yes? If so, let me know in the comments that you're feeling a little bit more confident. I'd really like to see that. I see some yeses on TikTok. Thank you. Um, yes, Naomi says yes. You could still win. They're just going to balance things out. And like I said yesterday, friends, some of these officers, I even have some of them are even fans of this show and other shows. Some of them, they are not gonna, they're not gonna do all of that. It's just human nature. Some will, some won't. So we'll see. It's going to be interesting to see how this is implemented, but I think you could do it. All right. And if you decide not to file, because I do see some folks trying to discourage you on Facebook. I see those comments. It's okay. Let them do their thing. Um, you know, be careful who you're listening to. Get some facts, get some truth, speak to professionals, and then make your decision about whether you're going to apply or not. Now, I have been getting some questions too from even some of our plaintiffs. I've seen questions coming into our office. At least the team told me yesterday that they were getting a few questions from plaintiffs. So if you are, for instance, you have an adjustment of status case and you're thinking, wait a minute, how is that going to impact maybe round two or round three or round one, whatever round you're in? Should I ask for a refund? Should I pull out? That's always your decision, by the way, whether to ask for a refund or not, or withdraw from anything. My thinking is this: I don't think there's any reason for you to be moved and try to um, retreat. Because if you were to pull out of a lawsuit, or if you decide not to onboard to a lawsuit, whether it's ours or Impact Litigation or Jim Hacken or Red Eagle, Morrison, if you decide to not join, your case is still going to be there at USCIS, and they're still going to maybe send that RFE at some point, asking for more evidence. They're still going to, consider applying this to you. Or I don't know if they're going to maybe not touch it because obviously there's the adjudication hold that's on your file, unless you're part of a lawsuit that had gotten a stay or a preliminary injunction that is working. Okay. So I don't see any reason why you should be moved, but I could understand everyone right now. No one understands really what's going on. So I get it. I get it. You could still ask your questions. Fine, no problem. Okay, so you can do this. Do you practice in other states? Do we? Yes, we do. Yes, we do. This is a nationwide practice, 50 states. This is immigration, which is federal law, and we are, what's that slogan again? Everywhere you want to be. No, I'm just kidding. We have clients all across the US, and we're working hard and doing great things, changing lives. And yes. How do we ask questions here or elsewhere? I don't know. How do you do it? I don't know. How do you ask questions here? That's funny. Thank you for sharing this live session. You would just put your question in the chat. It's going really fast. Uh, do you come to, as someone I interviewed with a media person today, and he asked the same question. It's if you're in another state, do you come to represent clients where they are, or do you send a representative? Okay, so the way that we do it at McBean Law is this. Certainly, USCIS just changed its policy saying that interviews, if you're going to bring an attorney to an interview with you at their field office, that attorney cannot do it telephonically anymore. They must be there in person. So we do go in person to some places, some states in the tri-state area, really, and then we work with our network in another state to appear with you in person, or we would have to, in some cases, send an attorney to your state. It just depends on the circumstance and our availability to travel, okay, during that time. For court, we represent clients nationwide as well because the removal system is different from USCIS, and it does allow attorneys to do WebEx hearings. So we're able to represent our clients in many different places. Hello, Mitri. Good to see you. Good to see you. If you missed earlier, I shared with you a checklist of documents that I think you should really begin pulling together in the event you'll get a request for evidence that USCIS might send you if you have a pending adjustment of status case with them at this time. Does the new memo apply to pending cases? Yes, I do believe that it applies to new cases. We're still waiting on guidance from the government about whether I'm wrong about that issue or not. 500,000 adjustment of status cases are processed each year. Half of those cases are spousal cases, and they have an obligation to move your case along. And if there's an adjudication hold on your case, you have a right to challenge them through litigation and put your argument before a federal judge to get that adjudication pause lifted. Okay. Freedom now, guys. Freedom now. Thank you, Laura, for being here. Freedom now. All right, let's go down to, let's see, does this memo, by the way, I don't have all of the answers. I just want to be upfront with you. There's still a lot that we don't know because the memo is very vague. Does this memo apply to those who already have been interviewed for a marriage-based green card? The interview went well on May 1st, F2A category. I'm glad to hear that the interview went well on May 1st. Today is May 23rd. Okay, May 23rd. And you haven't heard back from USCIS yet, right? So I'm curious to know what could be going on there. But yes, it does apply to cases that are pending. Whether they're going to apply it to you who have already been interviewed, I don't know. It's hard to say. I don't know. It just depends on I would think, honestly, you should have gotten a response by now from USCIS after being interviewed on May 1st, or that date that you said, May 1st. All right. Thank you. Does the new memo impact EB2 or employment-based cases? It's adjustment of status. So, yes. Okay. Adjustment of status. Now, You sound like you could very well be in lawful status still, which would be great. And also, you're doing an employment-based case, which, as I've mentioned earlier, that the spokesperson said that if you can prove that, you're within that, you fall into that bucket of economic benefit or national interest, then they're not going to apply this to your case. So that's a good thing. We'll have to wait and see. Thank you. Thank you. Um, Someone said I interviewed on April 30th, no response yet. Uh, does this apply to someone waiting on citizenship? No, this does not impact green card holders, okay, who then apply for citizenship. What is the cost of a consultation? The consultation cost is $300 for my colleagues and $399 for me. I actually had two consultations this morning. Sometimes, so a couple of times a month, I have Saturday appointments as well. So you could inquire with the team if a Saturday morning works better for you to see if you could book on a Saturday with me. Happy to do it. Although I would have really loved to sleep in this morning. Yesterday was so intense. I'm still reeling from yesterday with this news and everything. But I woke up feeling like, okay, I think there's a way of handling this. Let me share it with you. How long is the consultation with you, please? It is 30 minutes, but as for those of you who meet with me, know that the McBean of 2026 is not the McBean of 2021. um, I don't rush my consultations anymore. Sometimes we end at 30 minutes, sometimes we go over, and I'm fine with it. I just don't care. It doesn't matter so long as I feel that I've added value to you. But don't expect an hour, of course, but I just don't rush you anymore. Back then, we were just all over the place because we had so many. It was during COVID, and we were growing rapidly during that time. Um, the memo, from my understanding, doesn't apply to refugees. I'm seeing a lot of those questions. Okay, will it impact you if you've already done biometrics? I think so, yes. That wouldn't have anything to do with this. Um, let's see. Can you travel with your 2-year conditional green card internationally? Yes, you can. Does the new memo apply for adjustment of status to a parent? Yes. It does. My interview is scheduled in late July. Any advice? Prepare for that interview. Take a look at the document checklist I don't want to call it document checklist, ideas I've shared in this live session, and start gathering all of those documents in the event these issues come up, and also the topics, the questions that I outlined in the very beginning. Be sure that you have an answer to those questions. And if this is a marriage green card interview that you're walking into, you could also buy my course. I have a course out there on how to prepare for that interview. It's a terrific course. It'll take you an hour to go through with your spouse. So just Google my name and the course and course. It'll come up. Marriage green card interview prep. It'll come up in Google. Okay. Let's go. Given the current situation where we hear different news every day, do you recommend filing an individual lawsuit against USCIS in order to get the hold lifted from my employment green card? So we through Lyft, we believe the answer is yes. If we being the Lyft legal team believe that, here's our beliefs, that this is wrong, and the government is doing something that is illegal, and you've already paid your fees. You need your work permit, you need your green card, you need whatever it is you're seeking. So, despite the news that we're seeing with immigration these days, you still have a right to go forward. The point of what they're trying to accomplish here, as you guys know, is it's all in the mind. They want you to be curled up in your bed right now, feeling defeated, or on your phone right now, trying to figure out what will life look like for me back in Guatemala or Jamaica, or how could I transition? That's what they'd like for you to be doing on a day like today, thinking about self-deporting and leaving the United States, when in fact, many of you who are watching this live session, you're concerned about your adjustment of status application because you felt that you are eligible to adjust your status or eligible to apply for a work permit, and you went ahead and did so. And the government took your fees, and they have an obligation to finish the process for you and be fair and just. So, it's either you curl up in your bed and you cry and you despair and you dream about, let me transition, how will I earn an income back in so and so, and how could I get my money there? How could I get the money out of the bank account in America into the bank account there? Instead of thinking along those lines, well, think about, well, how could I actually overcome? How could I actually win? So that it's your choice to make. Your choice, your decision. Double tap the screen on TikTok. The government is cleaning out America. That's what someone on TikTok just said. That is not a McBean thing. The government is trying to shut down legal immigration on many different sides. That's really part of the intent here as well. They realized that from a public policy standpoint during this election year, things went too far in Minnesota, and so now they've shifted the focus to the wonky stuff, the legal stuff, the policies, and they're saying, okay, let's focus on those issues because maybe Americans won't care that much, that we have told all these people that you could only apply for a green card back in your home country. Does this affect the 2-year conditional green card? No, it does not. No, it does not, because you're already a conditional resident. It does not affect you if you're seeking the I-751 removal of conditions process. Okay, let's go. God is going to work it out. Someone says here on TikTok. Yes, I agree with you. He can work it out. He can work it out. Let's go. Human rights, justice. Thank you. Good questions. Let's see. Do you think this would also apply to those in the F2A category, especially since the visa bulletin is now current? This applies to those seeking adjustment of status. So if you're current, the F2A is current and you meet the rest of the requirements for adjustment of status, this new memo, the guidance applies. Now, I do see questions about this, not questions. People are trying to throw darts at me in the comments, saying things like, people, this is not the law. This is not the law. This is just, here's the thing, guys. This is a policy memorandum that it is not something that Congress weighed in on and a law was written and the president, it's not. It's a policy guidance instructing the officers on how to conduct their work. That's what this is, okay? But it has a lot of power and it has a lot of weight, because it sets the standard that the agency is requiring of its employees. Like I said, some will do it, some won't. So we're going to hear, I'm sure we're going to see different results from this in the days ahead. Thank you. Any reason to worry if my I-485 is still pending after an approved I-130 in November? Is there an adjudication hold on your case? Is that the reason why? Otherwise, you might have something to be concerned about. You should speak with an attorney about this. Okay, let's go down a little bit. Can adjustment of status be done at court after a denial? Oh, yes, of course. And we've won cases, adjustment of status cases in court, for folks who are in a real complex situation. Okay. And by the way, if they deny the case, what they're looking to do next is place individuals in removal. I want to say this too about what's going on with the green card re-vetting, re-review. This is a real thing that's happening, by the way, for green card holders. If there are any green card holders watching, you probably heard me and read through, various sources and heard other lawyers and other real people, just non-lawyers, just talk about this issue of the fact that the government is involved in, they're engaged in reviewing green card applicants to see, did they make a mistake in times past? Did USCIS make a mistake? And I actually did speak with someone very recently who, unfortunately, a mistake was made. And USCIS, when a mistake is made, USCIS is, normally they would send you a letter indicating that here's what the mistake, here's what our mistake was and why we're rescinding this green card, and usually just really leave it at that. But in this one case that I encountered recently, y- USCIS didn't even send a letter. What ended up happening was the individual was just placed in removal. So they're starting to do some cruel things like that, just go straight into the removal system into to flood the courts. So I suspect that with this new policy, if folks cannot win their adjustment of status argument or case, that they're going to just shift people into the removal system. There is still a way to win and succeed and be victorious nonetheless. I think that's why that person asked that question. Um, it is still very possible um, to win it in court. All right, let's see here. Okay, so someone says that someone is asking, well, if a person comes in through the K-1 process, and then need to adjust their status, how will this new memo impact that person? That person would have to, um, that's a good question, actually, because I haven't seen any carve out for this particular visa entrance. I would suspect that that person still will be held to that a heightened standard of proven that there are more positive things about her versus the negative, right? Because, think about it from this standpoint. A person can successfully get that K-1 visa. That's not that hard to do. Sometimes they could even misrepresent, as let's say, for instance, that person was in the United States 15 years ago and then and overstayed and tried to now get a K-1 visa and maybe didn't indicate previously that on that visa application didn't indicate that, oh, I was in America 15 years ago. It even could have been under a different name. People do all sorts of things with these visa applications. So it's possible for that person to still get that K-1 visa, come to the US. Now they're doing adjustment of status, and USCIS looks back and start connecting dots and say, but wait a minute. We found a record of you here in the United States 15 years ago, and back then you did overstay or whatever the case might be, and or there was a different name, or you misrepresent, so I think that they're still obviously going to do the scrutiny that they're going to do, to look back to see if you've committed any fraud or false testimony or anything like that. That's what this memo is all about, reminding the officers that, hey, we really want you to drill down. Don't skip this step, drill down before you make that decision. Does this affect someone who is married to a U.S. citizen? Yes, it is. It is applicable to those individuals as well. Can you file for just the I-130 in the United States and later the I-485 in your home country? The I-45, just the I-45 can only be filed by individuals inside of the United States. Um, I don't know about how it impacts those under the Cuban Adjustment Act. Not sure yet because, as you know, the government treats certain people a little differently from time to time. Okay. Oops, let's go here. Will it affect my child to sponsor me at 21? It will impact that if this government is still in power when your child is ready to file for you. Yes, I see how this will impact that case going forward. Friends, as I've mentioned, in all transparency, I don't have all of the answers. Many people don't at this early stage. I suspect that the government doesn't even have the answers. They just put these things out there and create quite a bit of stir, confusion, and fear, and light a fire under people, and in the wrong way. And then they later come out with clarifications, backtrack, and you know how it is. That's how it's been since last year. So I suspect that they don't have everything figured out yet, and certainly there is more to come. Um, how does this impact? How does this apply to someone with 10 years of lawful status in the United States on an F1 with seven master's degrees, an approved EB2 NIW, and a pending I-45? I suspect that you will be successful with getting your green card through that process because you have maintained lawful status continuously. If that is the case, right, continuously maintaining lawful status, you're doing NIW, you have an approved NIW, so you have already successfully proved that you're in the national interest, so to speak, and I suspect that you'll get your green card. And let me know if once that does happen. Is the N400 considered adjustment of status? No, it is not. It's that's related to naturalization. Let's see something here. Let's go here. How do you navigate this memo if you're leaving the United States? Would you trigger the 10-year bar? Yes, leaving the United States after overstaying, of course, after overstaying by a certain period of time triggers the 10-year bar. And speak with an attorney before you leave. Consider whether certainly a waiver, whether you're eligible for a waiver before you leave the United States. Otherwise, of course, you could trigger the 10-year bar. And not everyone is going to qualify, guys, for an I-601A waiver. Some of you will, if you choose to finish your process, if you cannot adjust your status and you do go back to your home embassy to finish the process, some of you will need a waiver after the embassy interviews you. There's, the way that I view things, you know, for some people it's a lengthy strategy, and you'll go through different phases. But if you trust the process and can certainly see the end from the beginning, then it's worth, getting on that pathway if you can afford to make the sacrifices of maybe leaving the United States. For some people, some of you, this is not certainly for everyone, but if you can make that sacrifice to leave the United States for a period of time, and you know what your game plan is and how you will sustain your family and yourself financially and otherwise, emotionally, mentally, and physically. For some people, they're fine with it. They actually want to go back for a few years because they miss their homeland, and they would like to go back and finish building that home, or go into that home that they've been building all these years and wait on their green card process. If that's your plan, terrific. Map it out, however, with an immigration attorney so that you're crystal clear on how to return to the United States successfully. Do not get on the path to do anything with immigration if you cannot see the end from the beginning. Um, if you're working with someone who is incredibly vague about what they're doing for you and where it's going, well, you've got to pause and question things, because you really need clarity, because it's your life and you want to see that end from the beginning. All right, thank you. With the USCIS policy memo, would it impact? Again, I've answered this question a number of times. People with the I-751 process, removal of conditions, no, it does not. It does not impact them. I'm still waiting to see how. I don't really want to comment on any of the humanitarian cases because I just don't know yet enough how this interacts with humanitarian cases. So that's why I'm ignoring you, intentionally ignoring those questions, because I just don't know. I don't know yet. Okay. That's why once I do know, I'll be able to offer my input on that. Okay. Super chat question, impact on folks and derivative applicant waiting for I-45, EB-1B, currently working on H-1B, expect all these acronyms, expect RFEs or delays, or things would move smoothly. So this is an employment-based pathway. I would say that it's possible to get an RFE. I would expect still an RFE, because you haven't really proven everything, proven yourself quite yet, right? You're still going through the process of proving yourself. Unlike the other person whose question I answered, who had already gotten an NIW approval, you're still going through that proving yourself process with USCIS. So yes, I would still expect an RFE under this memo. Okay, it's possible that things could go smoothly for you later on, but you're still trying to prove your worthiness to this government for that extraordinary, that green card, through that green card process that you're going through right now. Okay, let's go down a little bit here. How will this affect those in your current litigation regarding the adjudication hold? So as I said earlier, this pulling out of a lawsuit right now, I don't think is that wise, because you pull out and then what? Right? And then what? You'll still have to get your uh you still have to make your way through USCIS, one way or the other. I think that for those in the lawsuit with an adjustment of status case, certainly I think that some people might even get an RFE like everyone else, because once your case start to move and the hold has been lifted, USCIS will treat you like how they're treating other people under this new memo. So you also, whether you're part of a lawsuit or not, need to prepare yourself accordingly based on the topics that we discussed earlier. that's my answer for now. Lawsuit related strategies is not something that I'm going to be discussing publicly like this. There's other things I can say and things that we've already started thinking about and strategizing on as attorneys yesterday after this memo was put out, but I'm not going to go ahead and say too much. I see that, certainly there's so much chatter going on Reddit, and I know you have your Discord groups, and I do ask our plaintiffs to be very careful with respect to attorney-client information and emails and screenshots and all of that, that you don't do that publicly because it's not very wise to do so. But more to come in a different forum, certainly. Okay. All right, let's get back to one or two more questions and then we go. Yeah, again, humanitarian cases, not sure how this is going to intersect with what you're trying to accomplish on the humanitarian side. I've already went to my interview for adjustment of status, but I haven't received a response yet. You're in the same situation as the person who I discussed earlier. What about those who have already filed for adjustment of status in April? I do think this applies to pending cases. Our I-130 was approved, but the I-45 was denied. So what can I do now? Speak to a lawyer immediately, strategize, and consider whether you're still within the period of time to appeal that decision or not. But you've got to work really quickly because the government can issue you a notice to appear in immigration court. Let's see. Thank you. Got that. Why are some I-601As approved faster while others take years? So I don't know the answer to that question. I really don't. I think the shortest wait time that we've seen might have been 2 years, I think. Might have been 2 years. And then, of course, the norm is like 3 years for the 601A. Do I advise that you reapply for adjustment of status with a prior voluntary removal and warrant for a CASA that was later dismissed? I think we should speak, Crystal, one-on-one about this. When you say prior voluntary removal, you're here in the United States, you stayed, you didn't leave on that voluntary departure date. So there's a removal order. I don't think you're eligible for adjustment of status, but I might be premature in saying that. There's still some information I'm going to need to collect from you in order to kind of figure things out and give you proper advice. Thank you, Denise, for being here. Thank you for saying that. I appreciate it. Thank you. I hope after today, guys, that you don't worry too much. That was the intent here. That you do not worry too much, strategize, and know that some people will still be getting their adjustment of status approved while others will not. You be the one to be approved based on how prepared you are and how strong of a case you have brought to the government, and the fact that you know your records, you've requested your FOIAs, you've read them, you know what evidence and documents you need to begin gathering, you know what questions you need to be thinking about and how to answer those questions if those topics are brought up in an interview. You will not be blindsided. You can go in, you're prepared, you're confident, you have a good, strong lawyer on your side, and you could certainly win this. Gone are the days where you can be a child parent filing and you walk into USCIS with an adjustment of status case, just the two of you, your daughter and the mother, and the daughter is filing for the mother, And you don't need a lawyer for that, really. You don't, that's easy, easy. You don't need to bring anyone with you to an interview. But now things have changed that even those straightforward cases, they're going to turn into something bigger than what they should be. So prepare yourself even for those straightforward cases and be strong in your application and advocacy. You can win it. You can still adjust your status here. So watch the video from the very beginning, okay, and see what I've shared. I messaged you like 10 times. I just want to know if I had hardship case approved in 2023, how long does what? I don't understand your question. I don't understand the question. Oh, the AI summary on TikTok says that an attorney is answering questions about the USCIS memo on adjustment of status. AI summary. What about persons with upcoming interviews, marriage-based? Would the memo apply? Yes. All right, friends. This was awesome. Thank you so much for being with me today. I enjoyed meeting with you in this forum on this rainy Saturday. Watch this live session again and prepare yourself. You can do it. You can do it. Friends, I will see you on Monday at 1:00 p.m. Eastern Time for our Freedom Now show, which I'll do from here, my home studio. Have a good rest of your weekend, and I will see you on Monday. Bye-bye.